Well, hi there, folks. Gary McFarland here, talking about injured workers, where we give you the skinny, the lowdown, and the 5-0 on what's happening for injured workers in America and the need for minimum federal standards. Today's topic is going to be the demolition of workers' compensation, and we have a new advocate, and we can let her tell us and break it down to us what's going on. So let's hear from Monica Alvarez, is our workers' advocate and journalist in the field. Let's hear from her.
Observers say states moving away from National Commission recommendations. As reported by Work Comp Central, July 12, 2022, industry observers who gathered in Washington, D.C., Monday, to commemorate the 50th anniversary of the National Commission on State Workers' Compensation report, said states have been moving further away from the panel's recommendations over the last 30 years. States throughout the country took steps to ensure benefits were adequate and injured workers had access to medical treatment for industrial injuries after the report was presented to President Richard Nixon on July 31, 1972. Panelists at a U.S. Department of Labor program held Monday said there was a period of about 2 decades after the report was released in which most states moved to closer to aligning with the recommendations in the document. But since the late 1980s to early 1990s, they said, many states have taken to cutting costs by restricting which injuries are compensable and dismantling the notion that employers have to take employees as they find them. The 1972 National Commission report included 84 recommendations, including 19 designated as essential, for ensuring workers' compensation systems sufficiently protect injured workers. The Commission said nearly every worker in the country should be covered by a system that provides sufficient wage replacement benefits, medical care and assistance with returning to work, and safe workplaces. The Commission also said injured workers should receive benefits in a timely manner. The report said if states didn't adopt the recommendations within 3 years, Congress should force their collective hands by adopting national standards for work comp programs. John F. Burton, chairman of the commission, said during Monday's commemoration that while in some ways it was understandable that the Department of Labor and Administration didn't accept the recommendation for federal standards, it was nonetheless disappointing. He said that when the Occupational Safety and Health Act was passed in 1970, it had bipartisan support, so he expected to a similar level of support for improving work comp systems. Still, the report found traction within state governments. In 1972, the average state satisfied 6.1 of the 84 recommendations in the Commission's report. By 1980, the number was 12, Burton said. It was disappointing in terms of what we hoped the federal administration would do, but it certainly had a major impact on state programs, Burton said. Alan Pierce, a workers' compensation attorney with Pierce and Napolitano in Massachusetts and former president of the Workers' Injury Law and Advocacy Group, said he was working as a claims adjuster in 1972 when the report came out. At the time, the maximum benefit in Massachusetts was 2/3 of an injured worker's wage, capped at about $100, he said. The immediate impact of the report, he said, was for state lawmakers to increase the cap on benefits to equal the state's average weekly wage and extend the duration of partial disability benefits. At the same time, the state's workers' compensation agency transitioned to the Department of Industrial Accidents with administrative judges and an administrative review board. The department also opened up regional offices. The net effect in Massachusetts and most of the country, Pierce said, was that the ability of injured workers to quickly and efficiently receive adequate benefits increased substantially. However, he said it's often the case that when a benefit goes up, something else is taken away. Pierce offered a modified version of Isaac Newton's third law. For every action, there is an equal and opposite reaction. To explain what's happening, workers' comp change may produce a reaction, but it's very rarely an equal and opposite reaction, and I think that's kind of what has driven the last 30 years, he said. The reforms were followed by what he called the deform of workers' comp. Employers and carriers in the early 1990s were facing rising costs, he said, and some changes were needed, as insurers were leaving the state or otherwise refusing to write comp coverage. He said the easy way to fix rising costs is to cut benefits, which is what lawmakers did. Temporary total disability duration was cut to 3 years from 5. Benefits were reduced to 60% of a worker's wages from 66.7%, and the work injury was required to be the major cause for proving a case when the worker has an underlying condition. I would have liked to have seen a scalpel, he said. I think we say a machete, frankly. Emily Spieler, a professor at Northeastern University School of Law, said there have been extraordinary changes over the last 30 years with how people think about workers' compensation. In 1972, she said, she doesn't even think there was a question about the underlying assumption in work comp that employers took workers as they found them. The idea is that workers' compensation provides benefits to people hurt at work, even if they had a pre-existing condition. States throughout the country are now moving to exclude coverage for pre-existing conditions, she said. In some states, the injured worker has to prove employment was a major contributing cause of an impairment. California requires injured worker benefits to be reduced through apportionment by the percentage of the condition that is attributed to a pre-existing condition. She said states are also now looking to find ways to reduce compensability for conditions that might be related to aging. So there's been a whole mechanism by which people have been excluded from the systems now that didn't exist in the past, she said. The idea of liberality, that all the things being equal, the injured worker should get the benefit of the doubt, is also in the ropes, Spieler said. The U.S. Supreme Court threw that are for the federal Black Lung Program, and now almost all states require a worker to prove by a preponderance of the evidence that an injury or impairment is work-related, she said. That increases the evidence workers need to prove their claim as well as the likelihood of litigation and the need for lawyers. And some things were never solved, Spieler said. For example, the commission had a timetable for including farm workers in state comp programs that most states still haven't implemented. There are still waiting periods to get benefits in some states, and others require a business to have a minimum number of workers before it has to carry workers' comp coverage. We never made it all the way to what the commission recommended, and now we've had substantial cutbacks in the availability of benefits and increasing numbers of studies that show people either aren't filling or aren't getting benefits when they have legitimate injuries or illnesses, she said. Christopher J. Godfrey, director of the Federal Office of Workers' Compensation Programs, said the Department of Labor issued its own report on workers' compensation systems in the final months of the Obama administration that found state comp systems were moving away from the recommendations of the commission. The report warned that workers were at great risk of falling into poverty as a result of workplace injuries and the failure of state workers' compensation systems to provide them with adequate benefits. Massachusetts claimant's attorney and former WILG president, Pierce said he thinks the Department of Labor needs to maintain a role in overseeing state comp programs. While he said he doesn't see the need to threaten federal standards, Pierce suggested the federal agency could continue studying what is happening within state comp programs and use its bully pulpit to limit competition among states to have the lowest comp rates, what he called a race to the bottom. We've bottomed out, he said. We've squeezed from the injured worker all the cost savings that they could.